Dan, when I got pulled over, I got something that looks like a ticket, but there's no fine or penalty on here. It gives me a date to appear in court. Tell me what's going on.
It's a good question. Even though the police gave you what looks like a ticket, what they in fact gave you is something called a summons. And what you'll notice is that there's no dollar amount of penalty and you don't have an option to plead guilty or not guilty. This summons compels you, forces you legally to attend a court on a specific date and time. And a summons is very different from a traffic ticket and really goes to the nature of what you've been charged with. Driving while under suspension, it's really one of the most serious offenses under the Highway Traffic Act, and it's handled in a separate section, and it's called a Part 3 public safety offense. That's how serious this charge is. And as I explained in a previous video, when you're driving while under suspension, the law looks at you like you're driving this 4,000-pound weapon on wheels, and the penalties are very serious, and they include a mandatory 6-month license suspension and potentially jail time up to 6 months. Because the penalties are severe and will have a dramatic impact on your life, the charges against you has to be litigated through a defined legal process. The core of that process is giving you the ability to mount a legal defense. And the only way to fight your charges is to know what you're fighting against. Our legal system in Canada dictates that you have the legal right to all the evidence that the prosecution has against you, just so you can fight the charges that have been laid. And the only way to get that evidence to you is to force you to go to court, where the prosecutor will give you a package called disclosure, which should have all the evidence against you so you can effectively put together a strategy to fight back against those charges.
So I commonly get told by clients, I didn't know that my license was suspended. I never got notice. And if I did know that my license was suspended, I would never have driven my car. Does that mean that the charge will go away?
We hear this all the time from almost every client that's been charged with driving while under suspension. Unfortunately, the short answer is no. Generally, not knowing that your license was suspended is not a legal defense to the charge that you're facing, and not getting notice about the fact that your license is suspended again is not a legal defense. And the reason why has to do with the fact that driving is a privilege. It's not a legal right. And there's a big difference between a legal right and a privilege. So, for example, our kids have a legal right to an education, but we don't have a legal right to drive. Driving is a privilege. And when something is a privilege legally, you need to be proactive on the status of your driver's license. So, for example, if you get a traffic ticket, you have the responsibility to pay that ticket on time. And if you don't pay that ticket on time, then the law dictates that your license will be suspended.
Okay, so you've mentioned a few times now that this charge has an automatic 6-month driving suspension. And I've heard from people that you can walk away with a fine with no license suspension. Is this true?
Yeah, if you're found guilty of this charge, driving while under suspension, then the suspension is automatic, that 6-month license suspension. And it's not negotiable. That suspension itself is actually attached to the law, and you can't separate that penalty from the charge itself. And the charge of driving while under suspension is so serious that the lawmakers gave the prosecutor what is in effect a toolbox of penalties. And in addition to this mandatory 6-month driving suspension, you may be facing additional charges, additional penalties, including a period of probation and even jail time up to 6 months. The final outcome, however, is dependent upon a lot of factors that really go into the specific details of your case, including the court that you're charged in and the prosecutor and the justice of the peace that is attached to your case.